Please tell us your full name when you get comfortable.
My name is Michael Thomas Kispert, Nick.
Your witness state.
Sir, were you present during the inquiry that was made where the shirt was produced by Hector Rodriguez on the 20th day of April 2012?
Yes, sir, I was.
Where was that specific location?
Whisperwood Apartments, 7316 Swaddle Run.
Had you also previously in your investigation with this case conducted an interview with John Tischer?
Yes, sir.
Did they provide you with the address that they went to the morning that the Cady Way murders, the morning that the bodies were found in the Cady Way?
Objection, hearsay.
Overruled.
Yes, sir. He told me it was...
No. It's yes or no.
Yes.
He did give you the address? Or
He did not give me the address, no, sir. But he
gave you the location?
Yes, sir.
That was the same location you made contact with Mr. Rodriguez?
Yes, sir, it was.
I'm showing you what's been marked as State's Exhibits JO, JN, it's actually JL, JM, JN, JK, and JO. Like approach, Your Honor?
Yes, sir.
Take a look at those to yourself. Do you recognize those photos?
Yes, sir.
What are those photos of?
7316 Swaddle Run, the apartment where I made contact with the defendant.
Your Honor, at this time I'd like to move State's Exhibits JK, JL, JM, JN, and JO into evidence as the next State's numbered exhibits.
Objection?
Reiterate my last objection, Judge, regarding these, and also objecting that they're cumulative to each other.
Any further objections?
No.
Okay, over the defense objection, as previously argued and probably denied, be overruled. Objection is accumulative, would be overruled. Madam Clerk, accept them in numerical order, please.
JK is States 251. JL is States 252. JM is States 253. JM is States 254, and JO is States 255.
Showing you what's been entered into evidence of States 254. Can you describe to members of the jury what they're looking at here?
Sir, that's going to be the parking lot immediately adjacent to 7316.
Can you identify, and you can use the arrow and then you should be able to use the pencil if you press the arrow in the right corner. Can you identify where the front of the building would be from where this...
Okay.
So you would have to make a left turn from the parking lot and that would access the front?
Yes, sir.
This is going to be States Exhibit 255. What does that show?
Again, it's still the side of that same building. This photo, however, shows the staircase, which would access the unit, the upstairs unit, where I engaged the defendant on the 20th.
States Exhibit 253. What does that show?
It's a closer look of the staircase accessing that same unit, sir, and it shows the side of the building, the foliage there where it was described to me where Tischer may have been standing.
Now, when you're looking at this landing, and I'm showing you 251, where would have the apartment been that Mr. Rodriguez was located in?
So that's going to be as you go up the stairs to the landing. Imagine, if you will, that you just walked up these stairs. It's going to be the apartment on the left.
Do you recall when you were there on April 20th, there was a grill out on that landing?
Yes, sir.
Is a grill depicted in the position that you recall a grill being there?
I don't recall, sir, if it's been moved. I know that it got crowded up there with Sean and I. And
did you have an opportunity while you were out there to measure the actual distance from the point where the landing starts to where you would be able to go to the side of the building, the end of the building?
yes, sir.
What was your measurement of that particular distance?
It was 24 feet, 4 inches.
I don't have anything further with this witness.
Cross.
Detective, you just took these pictures within the last couple of hours, is that correct?
Yes, sir.
And can you say that they truly and accurately depict the condition or conditions as they existed back in April of 2012?
Yes, sir.
Vegetation was the same?
I can't answer that, sir.
Okay.
The building is the same.
May I approach the witness, Judge?
Yes, sir.
Sir, I'm going to show you what's in evidence as 254. You recognize that as one of the photos you took?
Yes, sir.
And did you measure the distance from that dumpster to around to the front of the apartment?
No, sir, I didn't.
How about from the, well, how far back does the actual building go?
Far back from the roadway?
Well, from the landing, where the landing comes off the, and I'll show you Exhibit 251. You see where the landing comes out to the ground?
Yes, sir.
From that all the way to the back of the building.
I didn't measure that, sir. I was concerned with Tischer's location compared to that landing.
So if Tischer said that he went to the back of the building and heard conversation, think that's feasible? All the way to the back?
I don't know what he testified in here, sir. I know that he told me he was on the side of the building listening to provide cover for his brother.
That's all I have, Judge.
Redirect.
No, Your Honor.
Is he free to go?
He is.
Defense.
Yes.
Thank you. Next witness state.
Juan Del Castillo.
Good afternoon, sir. Tell us your full name.
Juan Del Castillo.
Your witness.
Mr. Castillo, I'm showing you State's Exhibit 137. That's in evidence. This firearm was previously identified as one that was something that you possessed and owned at one particular point in time.
Yes, sir.
Had you shot that firearm prior to the date it was not in your possession anymore?
Yes.
And when you fired that particular firearm, was that ammunition that you had purchased and had loaded the firearm with?
Not purchased.
All right, let me rephrase that then. Was that ammunition that you had for the firearm that you loaded?
Yes.
And was that ammunition from a pool of larger ammunition?
Yes.
You had fired this gun prior. Did that gun have occasion where it would jam in the course of your firing and owning that firearm?
Yes.
In the course of the firearm jamming, would there be times where entire projectiles would be ejected in an unfired state in order to clear that jam?
I don't understand the question.
In other words, if you have a projectile when you're trying to fire the firearm and it jams, how are you clearing out that jam?
You had to pull the receiver back in order to clear the casing.
And when the casing would clear, then the casing would then no longer be part of the firearm magazine, correct?
That's correct.
And when it would be no longer part of the firing, part of the casing, part of the magazine or the firearm, it would still be in an intact, pre-fired form, correct?
Correct.
I don't have anything further with this witness.
Cross-examination.
No questions, Judge.
Is he free to go?
Yes.
Yes.
Have a good day.
Thanks,
you.
sir.
Next witness state.
Stay with rest, Your Honor.
Okay, ladies and gentlemen, will the lawyers approach at the sidebar, please, with Madam Court Reporter? Defense want to put on a case?
Yes, Your Honor, we would call Randy Loader.
Brandy Loader. Please speak into the microphone. Please tell us your full name, spell your first and last name.
Brandy Loader, BRANDIELODER.
Your witness, Mr. Bankowitz.
Thank you, Your Honor. Ms. Loader, what is your relationship to Hector Rodriguez?
He's the father of our son
And how long have you known him?
since October of 2011.
How long, well, first of all, have y'all resided or lived together during that period of time?
Yes, sir.
And were you living together in April of 2012?
Yes, sir.
Where were you living?
In Nob Hill Apartments on Cimarron and Aloma Avenue.
Do you know the address of the apartment complex?
I think my address was 626.
Is Nob Hill right on the corner of Aloma and 436 or Cimarron? Be the northwest corner?
There's something right on the corner. I think it's a church. But if you're on Aloma, I don't know the directions. I think if you turn north onto 436, it's your first left.
Okay. And how long did you live there?
Four months.
And did Hector Rodriguez live there with you?
Yes, sir.
When did you begin living there?
February of 2012.
Directing your attention to April the 14th of 2012, where were you working that day?
I was working at a racetrack gas station on Aloma Avenue.
Okay, is that near the Sun something apartments across the street?
Sun Bay.
Sun Bay Apartments?
Yes, sir.
How long have you been working at racetrack?
Right now,
At that point in
at
time?
that point, I believe it was 2.5 years.
And what were your duties at that location at the time in April of 2012?
I was the overnight shift manager,
What time did you go to work?
9:30 p.m.,
What time did you get off of work?
7 a.m.
How would you get to work at that point in time?
I would walk
And how long was that walk?
about 30 minutes.
And when you say walk, do you mean walk from your apartment?
Yes, sir. About, I think it was 1.1 miles away.
And how would you get home in the early morning hours?
I would walk.
Same distance?
Yes, sir.
Same length of time?
Yes.
On April the 14th, when you went to work that evening, prior to arriving at work, when was the last time you saw Mr. Rodriguez, if you saw him on that day?
He walked me to work,
And what time did you get there?
9:30.
And could you see what he did after he walked you to the store?
No, I know that he came back in.
About what
Later.
time?
It was between 10 and midnight. I can't really place an exact time on there, but he came in to buy beer. And, I'm sorry.
Let me stop you for a second. Did he have money to buy beer?
Yes.
Okay, was he working at the time?
No, sir.
Do you know where he got the money to buy the beer?
No.
Did he make that transaction through you or somebody else at the station?
I believe it was through me. I'm pretty sure.
You know what kind of beer he purchased?
I don't remember.
Do you know what his beer of choice was? I mean, like Miller Lite, Bud Light, Amber Bock, do you know?
Heineken, Miller, High Life.
You ever see him purchase Bud Light?
Yes.
But you don't know what he purchased that night.
I don't remember. No, sir.
When was the next time you saw him on the 14th?
That's that same night.
Yes, ma'am. Other than purchasing the beer.
He came in and he told me that he loved me, gave me a kiss, and then he left.
About what time was that?
I don't know. Maybe closer to midnight.
Did you see him with anyone around the front of the store?
No, sir.
Were you particularly looking for him out there?
No, sir.
When was the next time you saw him after about midnight?
Whenever I went home, I got out at 7 a.m. and I walked home and he was there whenever I got home.
And that would have been the 15th, correct?
Yes.
Sunday?
Yes, sir.
And did you go directly home?
Yes, sir.
And what time did you get home?
I would
7?
estimate around 7:30.
7:30, okay. And was he at the apartment when you got home?
Yes, sir.
Did he appear disheveled or dirty or anything like that?
No, sir.
What was he doing when you got there?
I can't say for a fact what he was doing because I know whenever I would get out of work and I would go home, if he didn't walk me home, he would always be at home waiting for me. He might have been laying down or watching a movie. I can't say for certain.
But he was in the apartment.
Yes, sir.
Did y'all have breakfast?
I can't remember. Most likely we did, but I can't.
Did you go to work that Sunday?
Sunday night, yes. Same
About what time? 9 o'clock?
Yeah, we would leave at 9 o'clock and I would get there at 9:30.
During the time from your arrival at home at 7:30, well, before you answer that, did he walk you to work that day on the 15th?
Yes.
Did the two of you ever part company? In other words, did he leave you? Did you leave him during that day?
As far as I know, he didn't, but I did sleep. But whenever I would wake up, he would be there.
Okay, what time, do you know what time you went to sleep approximately?
My best estimate would be between 8 and 10.
In the morning?
Yes, sir.
And you know how long you slept?
No, because I would sleep and I would wake up. We didn't have an alarm clock and I didn't have my cell phone to be able to check the time because the cell phone was broken.
Okay. When you would wake up, was he there?
Yes, sir.
Do you recall about how many times during that day you woke up and went back to sleep?
No, sir, I don't.
Was there any significant length of period of time that you would have been asleep during that day? It's like 4 or 5 hours.
I'm trying to think because it was very early in my pregnancy. I would be very tired, but I would have a hard time staying asleep.
You were pregnant at the time?
Yes, sir.
So would you be up often, using the restroom, trying to get more comfortable, things like that?
I would be, but I can't really give a time because I don't have a clock as a reference.
But each and every time you awoke during that day, Hector was there, correct?
Yes, sir.
Did you and Hector ever go to his cousin Sammy's house?
Yes. Whenever I
That
had.
day?
Oh, no.
When did you go there?
Whenever I had my car, I would take him to his cousin's house. I would drop him off before I went to work, and then I would go to work and I would pick him up in the morning. But that was whenever I had my car.
But on the 15th, did the two of you go to his cousin's house?
No, sir.
Did you have any way to get to his cousin's house from where you lived?
No, sir.
No transportation?
No, just
Now
walking.
You said when you had your car, what happened to your car?
I didn't have insurance on it, and my license got suspended, and my registration got revoked in the beginning part of February. So we were no longer driving it.
Okay, so it didn't have tags, didn't have registration, and you parked it.
There was a tag on it, but the registration was expired, so I couldn't drive it without it being obvious that the tags were expired.
And did you say you had no insurance also?
Correct.
Is that why the registration got suspended for
Yes,
lack
sir.
of insurance? When were you able to get insurance on the vehicle so that you could drive it?
I believe it was June or July of 2012.
You had to save up the money for
Yes,
the
sir.
insurance? Okay. Now, you mentioned earlier about your phone and being a reference point for time. Did you have, on April the 14th and 15th, an operational either landline phone or cell phone?
No, sir.
And did something happen to your cell phone or cell phones? Well, first of all, did you have a landline phone at all?
No, sir.
Just cell phone?
Yes, sir.
How many cell phones did you have?
Just one.
Did you have kind of a backup phone?
Yes, the screen was cracked on it, but it was still operational for a while. But at that time, I had no cell phone whatsoever. Both cell phones had been broken.
How did they get broken?
I threw them.
So did Hector have a cell phone?
No, sir. He would use mine.
When he had one, he
When-
would use yours.
Yeah.
On April the 14th and 15th, were any of the cell phones which you owned operational?
No, sir.
Do you know if Hector was aware that they weren't working?
Yes.
How do you know that?
Because we were arguing and I got mad and I threw the phones right in front of him and broke both of them. I think I threw one into the wall and I threw the other on the floor.
How can you be so sure about the dates that you did or did not have a cell phone?
Because at one point in time, Hector asked me to check the phone records he mentioned the dates, and he asked me to check the phone records to see if there was any calls during that time.
So did you go to your phone company and
Yes,
get the
sir.
records? Okay. When you got home on the 15th after working in the morning, I asked you earlier if you noticed anything unusual about Hector, and you indicated, I believe, no. What about his clothes? Do you remember what he was wearing?
No, sir.
Did he have a white shirt that said Coogie, C-O-O-G-I, on it?
Yes, sir.
Do you remember if he was wearing it that day?
I don't remember.
How about when you saw him the night before?
I don't remember because there was nothing that stood out to me that day against any other day. I can't tell you what he was wearing.
What was your normal pattern as far as washing clothes at that time?
Objection, relevance.
Overruled.
It was on an as-needed basis. I had, I believe, 2 pairs of pants and 2 or 3 work shirts. And when they would get dirty, we would wash them along with all the rest of the clothes because my work clothes would get dirty before all the rest of them.
Would you wash them with Hector's clothes?
Yes.
Did you have a laundry there at Nob Hill Apartment Complex? A laundry room
There was, but it was always broken, so we didn't use it. We used the one across the street.
in the little shopping center behind Denny's there on 436?
Yes, sir.
And if you were to look back, do you think you wash clothes generally once a week, twice a week?
Between once and twice a week, I would say.
Did you know Jesse Davis?
Yes, sir.
Excuse me?
Yes, sir.
How did you know Mr. Davis?
He would go into racetrack, and sometimes I would go over to his house.
You and Hector?
Sometimes me and Hector, sometimes just myself, sometimes me and a friend.
What was the purpose of you going to Jesse Davis's house?
To buy drugs.
Was he known as the local drug supplier
Yes, sir.
in that general vicinity of Aloma?
Yes, sir.
Did you know other people who knew Jesse Davis?
Yes, sir.
How many other people?
Jesse kind of had the reputation that everyone in the area knew him or knew of him.
You mentioned reputation. Do you know if he had a reputation in that?
Mr. Lewis, let's wait for the question. Once the question is finished, then you can make an appropriate
Thank you, Judge.
objection.
Do you know if at that time Jesse Davis had a reputation in the community as being a drug dealer?
Hold on
Yes.
one second. Any objection from the state?
What was the question?
For being a drug dealer?
Drug dealer? I do have an objection to the question.
The form of the question? Is that your objection? Response?
No, sir.
Okay, overruled as to form of the question.
If I can specify, I think you'll understand, there's no, reputation is not personal knowledge, and I think that's already been testified to, so we're going to object on relevance basis.
Response?
She said she knew a lot of people who knew him in the community, and she used the word community as a reference point. And a lot of people who knew him knew her.
I'll sustain the objection until you can establish what the community is, and then we can ask the question.
Do you know what I mean by the word community?
The surrounding area, people who work in the area and live in the area.
And how many people are you talking about that you believe knew Jesse Davis and his reputation?
Probably between 2 to 3 dozen.
2 or 3 dozen?
Yes, 2 to 3 dozen.
I'll ask you the question again. In that community of those people who knew you and knew Jesse Davis, what was his reputation for being a drug dealer?
Judge, two things. Number one, I object to relevance. Number two, any answer that she would give would be elicited solely based on hearsay. She has already testified to her personal knowledge and her dealings with Mr. Davis.
As to both objections, overruled.
What was his reputation?
He was a drug dealer.
Among that same community, did Jesse Davis have a reputation for being a violent person?
Judge, we approach. I have an objection.
Yes, you may approach. State's objection is sustained. Next question, Mr. Bankowitz.
Judge, I believe at this time I have no further questions.
Cross.
Yes, Your Honor.
I know the area, yes, sir.
Is this the racetrack you work at over here in Aloma you used to work at?
Yes, sir.
Would your apartment, the Nob Hill Apartments, be in this particular area here?
Yes, sir.
So this would be Cimarron Boulevard?
Yes, sir.
This would be a Steak and Shake over here on Cimarron just south of Aloma?
Yes, sir.
How long a time period was it that you were no longer driving to work? Before April 14th, April 15th, 2012?
I believe that I stopped driving around the 6th of February, so around 2 months.
2 months?
Yes, sir.
And in those particular 2 months, Mr. Rodriguez would frequently show up and walk you home from work, correct?
Yes.
Would you describe him as very possessive of you?
He was very protective.
He would show up and he would, on foot, and he would walk you home.
Yes, sir.
Approximately 6 months before the incident that happened on the Cady Way Trail, that's when you first met Hector Rodriguez? 6 or 7 months?
Approximately, yes, sir.
You had only been working at that racetrack actually a few months prior to that, correct?
Yes, sir.
Is that correct?
Yes, sir.
You met him because he would hang out at the racetrack in the middle of the night. Isn't that true?
Yes, sir.
Your relationship first started with him because he would supply you with substances. Isn't that true?
We would get high together, but it was more than that. I was asked the same question in my deposition, and I had a lot of time to reflect on it.
Okay, so you're changing your answer that you gave in the deposition today?
I said possibly whenever I answered in my definition, or answered my deposition. Now I know that it was, after thinking about it, it was more than that. More than just that we would get high together.
But you would agree when you were deposed July 11th, which would be less than 3 weeks ago, your response was that what you had in common when you first met were drugs.
I said possibly. I never gave a definite answer. I said that was a possibility. Since then, I've had time to reflect on it and consider why I was first attracted to him and why our relationship grew.
Ma'am, you got an apartment over on Knob Hill, lease was in your name, is that correct?
Yes, sir.
That was how many months after you had met Mr. Rodriguez?
Approximately 4.
Approximately 4?
Yes.
He would crash at your apartment on a nightly basis?
He was living with me. I wasn't crashing. He was living there with me.
He was living with you?
Yes, he didn't have an identification card, so I couldn't put him on the lease.
You paid all the bills, did you not?
Yes, sir.
In fact, the only thing he contributed was when you weren't making it and needed some money, he would ask his father and he would produce some money.
Yes, sir. Yes, sir.
You didn't know him to occupy his time at all with any job other than working with his father a couple days a month. Isn't that true?
Yes, sir.
Part of the drugs that he would supply you would be both cocaine and Xanax, wouldn't it?
Yes, sir.
You testified on direct examination that when you were asked specifically regarding your contact with Mr. Rodriguez on the 14th day of April 2012, that you remember him being in the store. Is that correct?
That was the night in question, right? Saturday night? Yes.
Do you remember him being in the store?
Yes, sir.
You said, I think specifically on direct, that you remember him buying beer.
Yes, sir.
Did you ever give a different answer than that 2 weeks ago, your deposition?
Improper impeachment at this point, objection.
Sustained as improper impeachment. You may rephrase or use the.
Did you ever give a statement inconsistent with what you just testified to?
Judge, I believe she has the right to see the deposition and where he's talking about.
Judge, I have a right to get an answer. If she doesn't remember, it's a different response, a different follow-up question than if she says she does.
Are you trying to refresh her memory or impeach her?
I can impeach her, but if she acknowledges it, there's no need for me to show her the statement. So she's being asked if she recalls it.
Okay, the objection's overruled. Re-ask the question.
Do you recall if you gave a different statement regarding the last time you saw Hector on the 14th than Hector was in the store and buying beer?
I don't remember.
You do recall giving a deposition under oath at the State Attorney's Office on July 11, 2013?
Yes, sir.
Your Honor, if I can approach the witness.
Yes, sir. Page and line for Mr. Bankiewicz.
Pages 11, lines are 17 through 22. You can read those to yourself. Do you recall being asked the following question? Do you remember meeting with him on that night? I remember he came in. No, he didn't come into the store, I don't think. He came up, I was outside.
Yes,
Do you
sir.
remember that?
Yes, sir.
So now, 3 weeks later, you remember that he came in and bought beer. What, if anything, changed in that interim where your answer is different? Have you been following this case on the media?
No more than I've already stated.
So you have been.
I already said what I was following and what I had seen. I've had a lot of time to think about things that had happened and things that I had been questioned about.
Mr. Rodriguez had his own key. He could come and go as he pleased, correct?
Yes, sir.
And he was an adult, 30 years old, correct?
Yes,
And he
sir.
would come and go as he pleased, would he not?
Yes, sir.
So when you worked the night shift, you would agree that you would generally be tired when you got off work?
Yes, sir.
That would be normal?
Yes.
How many months pregnant were you during the days of 4/14, 4/15, around that period of time?
Approximately 2 months.
Approximately 2 months you were pregnant?
Yes, sir.
And again, that would be another situation where you would want rest after a shift at work, correct?
Yes, sir.
You do remember specifically that on the morning of the 15th, unlike other times during this period when your license was suspended, you remember specifically that after you saw Hector, isn't that correct?
Somewhat, yes.
Ma'am, you're under oath, correct?
Yes. I mean,
Just answer the question. You're under oath.
yes, sir.
Isn't it true that you have no specific memory of when you saw Hector on that particular day, what he was wearing, what the two of you were doing, that your testimony regarding you seeing him when you came home is testimony of routine that generally he would be home when you were there? Isn't that true?
Yes, sir. He would either be home or he would walk me home.
So again, you have no specific memory of April 15th at all, other than you believe he would have been home because normally if he didn't pick you up from work, he would be home when you got home, correct?
Not normally, he would be.
He would be.
He would be.
But you can offer no specific facts about the morning of the 15th from your own memory as you sit here today, correct?
Correct.
You did have the phone number of 407-272-4619, did you not?
Yes, sir.
And Hector did not have his own phone at this particular point in time, correct?
Correct.
Hector's practice would be he would use your phone and take your phone while you were at work.
Yes, sir, because I had a phone at work in case he needed to contact me or I needed to contact him.
So for all practical purposes, if Hector was going to give out a number for somebody to get a hold of Hector, the number he would give out would be the number 407-272-4619. Isn't that true?
Yes, sir.
Hector broke that phone previously in a fight, correct?
I broke that phone. I
You
broke
broke
two
that phone.
phones and an iPod.
But there was no new number on the 14th and 15th. That was the only number that you had at that particular point in time, right?
Yes, yes, sir.
Now, you said you remembered washing clothes at some point after the incident.
Yes, sir.
You don't recall specifically when that was, Sunday or Monday following the incident?
It was one of those 2 days. I don't recall.
You would wash your clothes and you would wash Mr. Rodriguez's clothes as well when you would do laundry?
Yes, it would be together. He would separate them because I have no idea how to separate laundry.
So where you would agree that the closest individual that Hector was to when you met and where you would drop him off all the time was at his cousin's house in Whispering Woods, correct?
Yes, whenever I had my car.
I'm showing you state's exhibits 252, 3, 4, 251, and 255. you recognize these?
Yes, sir.
And that would be the cousin that you're referring to, with Hector's, where Hector would spend all his time when you were at work, correct?
Yes, sir.
You were present when the police came to speak to Hector Rodriguez at that very location that's depicted in those photos. Isn't that true?
Yes, sir.
And you purposely did not respond to their request for you to produce Hector when they were asking you. Isn't that true?
Yes, sir.
You told them that he wasn't there when you knew he was, correct?
When I first woke up, I didn't know if he was there or not.
When the police got there at that particular time, and they asked to see Hector, you knew he was in the apartment.
Not at first. I had just woken up.
Not at first.
Right.
What does that mean?
I woke up, they asked for him. He wasn't out in the living room. I figured he wasn't there. I went into one bedroom, he wasn't there.
You come to that apartment.
I don't remember. I think I might have got dropped off that morning. I don't, because it was a long walk. It was longer. It was a longer walk than normal, so I think I got dropped off by a girl that I work with.
So you're saying here under oath that you didn't think Hector was in the apartment? His cousin's apartment that you're in when the police arrived on that date?
Yes, sir. When I woke up, he wasn't out in the living room, so I didn't know if he was there.
Did you spend the night there personally?
I was at work the night before, I believe.
Why were you there that night?
Because Hector had spent the night there, and we were going to go back to our apartment together whenever his cousin got out of work.
You spent the night there?
No, the morning. My night at the time was the day. I'm sorry.
So this was after work?
Yes, sir.
You were aware that Hector had spent the night there, right?
Yes, sir.
And the reason you went there and were dropped off there was because you knew Hector had spent the night there, correct?
Whenever I got there and I'd fallen asleep, yes.
Were you aware at all that the phone number 407-272-4619, were you aware on the early morning hours of the 15th day of April that that would have been the second to last number ever dialed on the phone of the deceased Jeremy Stewart?
Objection, speculation.
Sustained.
Do you know?
Objection, speculation.
She can answer if she has actual knowledge.
I found out after Hector got arrested that that was the case whenever he asked me to look into the phone calls, but it didn't appear to be an actual call because the phones were broken and the time on the call was 2 seconds.
But you acknowledge that that was your number, 407-272-4619, the number of the phone that Hector would use when he borrowed your phone.
Yes.
I don't want to get any further, Your Honor.
Redirect.
Assistant State Attorney asked you about routine, and if there was anything out of the routine, would that have jumped out at you and made you aware that something was different?
Yes, sir.
So, and at that point in time on the 14th and 15th, there was nothing in your life or his life that was different than what you did every day, correct?
That's correct, yes.
And every day you would come home or he would walk you home, and if he didn't walk you home, he would be there in the apartment,
Yes, sir.
and you two would go to sleep together.
Yes, sir.
And at that point in time, you were relatively uncomfortable with this new pregnancy,
Yes.
hard time sleeping,
Hard
Irri-
time staying asleep.
okay, irritable.
Yes.
Thank you.
She's free to go, Mr. Pankowitz?
She may be,
State,
yes, Your Honor,
free to
she may
go?
be excused.
Yes, Your Honor.
Thank you, ma'am.
Thank you.
Next witness defense.
Jesse Davis.
reporter. Ladies and gentlemen, jury, please leave your notepads on your chairs. Please remember my admonition not to discuss this case among yourselves. Please retire with the deputy into the jury assembly room. To the jury room. Thank you. Have a seat, please. Okay, the jury's exited the courtroom. Mr. Davis, you are being sworn in, and you indicated to the court reporter you do not want to testify. Is that correct?
That's correct.
Mrs. McGinnis and Ms. Malov, is Mr. Davis's attorney in the courthouse? Please locate him, please. Mr. Bankwitz,
Yes, sir.
suggestions?
If he, realistically, I don't know that there's anything the court can realistically do to him. You can hold him in contempt for each thing he refuses to answer. He gave a rather extensive deposition about 7 months ago, and he was very forthcoming at that point in time. At least I believed he was. And he's been in the Department of Corrections since. We brought him back believing that he was going to be forthcoming and testify in accordance with his deposition. He's refusing to do that with 2 consecutive life sentences. 6 months on each question isn't going to make a whole lot of difference to him, I would think.
Well, that's
The
going to be a
alternative
question.
is
There's going to be
to
a question.
use-
There's a question for the state, though. Your plea agreement with Mr. Davis that included him testifying in this matter.
Is that what your representation is?
That's my question to you.
No,
Is-
not that I recall.
Okay.
There was no proffer and there was no agreement with Mr. Davis.
And
No
I
recollection.
was in court the day he entered the plea, Judge. I don't believe that was any part of a plea agreement, that he testified for the state or the defense, which is why we said his deposition almost immediately after his plea.
Cindy, do you have the plea form? Thank you. I'm looking for a rule book here. Usually go online, but I believe there's a rule of criminal procedure that may come into play. I might be 3.710 if my memory is correct, or 3.170. Yes, please. The court is referring to 3.170G, vacation of plea and sentence due to defendant's noncompliance. The state of Florida waived the death penalty in this case and also entered a plea of guilty to the offense. Is correct, Mr. Lewis?
We didn't waive the death penalty, Judge. We did not seek the death penalty on this case. There was no agreement whatsoever with Mr. Davis regarding his pleading to these counts.
I thought you had an agreement to drop the pending attempted murder charge against him. Was that part of the plea agreement? We didn't Tischer that. I think was concurrent. Yeah.
Paragraph 5B. B as in boy. States, the prosecutor and I have agreed to the following, : that I will give a complete and honest proffer as to the events of the homicide and cooperate of any future prosecution. We are in a future prosecution.
Right, Judge, he's not cooperating with us. We have not attempted to call him as a witness.
Mr. Benkowitz, when you indicated that there is no remedy, there is a potential remedy under that rule.
I'm sorry, Judge?
There is a potential remedy under the rule.
What is that remedy, Judge?
Remedy is the court can set aside his plea and sentencing, and he stands charges as if he had never entered a plea. And I'm
Judge, can we approach?
absolutely, Mr. Lewis. Okay, we're back on the record. State of Florida is present. The defense is present. Mr. Rodriguez is present. With our interpreters, Mr. Hooper for Mr. Davis is present. Mr.
Yes,
Hooper,
Your Honor.
good afternoon.
Good afternoon, Judge.
Okay. I've been informed by my assistant that we are ready to come back to court. We have a resolution to the issue, Mr. Hooper.
That's maybe a tad optimistic, Your Honor. I spoke to Mr. Davis, and he means no disrespect to Your Honor or the court, and no disrespect to either counsel, but he has voices in his head telling him not to testify, and he feels compelled to obey the voices in his head. He's unable to resist them, and they keep telling him not to testify.
As the court recalls, we had competency issues with Mr. Davis, and at the end of the day, the court, after a multi-day competency hearing, found that the defendant was competent to proceed. And what I'm hearing from you is similar to what I heard then, correct?
Correct, Your Honor.
The court has some alternatives here. Your client does not even want to take the oath. Until he takes the oath, he is not considered testifying. The oaths are pursuant to 90.065 or 605 in regard to the rule. And if your client does not want to take the oath, he is subject to criminal contempt of court. If I direct him to take the oath and he declines, he is subject to direct criminal contempt of court. Direct criminal contempt of court without the assistance of a jury would be a maximum of 6 months in jail or a $499 fine. He is serving 2 consecutive life sentences. One of the things I've been researching is the rules of criminal procedure, not judicial administration. The rules of criminal procedure have been amended that gives the court the authority under certain circumstances to direct the Department of Corrections to administratively punish the individual, taking away certain rights and privileges other inmates may be entitled to. One of the issues at the plea colloquy for Mr. Davis was not a firm agreement with the state of Florida. And Mr. Lewis and Mr. J, you can correct me if I'm inaccurate with my memory, but there was a loose agreement between the state of Florida and Mr. Davis about the state of Florida communicating to the Department of Corrections to request or recommend placement within their system in a proximity to the Central Florida area so that his family can have access to him. Would that be accurate, Mr. Hooper?
Yeah, yes, Your Honor, and along those lines, Judge, I want to properly advise my client, and I haven't at this point, because I did advise him he could be held in contempt and given additional time for contempt. I was not aware of the new procedure where he could get privileges taken away. Perhaps if I
Under the 3.850 rule, subsection M, which is a new rule, it talks about certain circumstances. It doesn't specifically limit it to 3.850, but it indicates a list of potential actions by the convicted individual, who your client is, that could subject him to those administrative penalties.
Okay, perhaps if I could have a moment to explain that to him.
I have never done it. I am not aware of it ever happening, but it is an option for the court. Okay?
Okay, I would like to advise him of that then.
Now, I don't know, and you may want to advise him, and this is probably totally collateral, but we do have to advise people on collateral issues,
Yes, Your Honor.
that if I do hold him in contempt, that may affect the Department of Corrections internally with other administrative issues, such as privileges and rights and things of that nature. Because I think we do know generally that if someone is going to be serving another sentence consecutive to their DOC sentence, that affects things within the Department of Corrections, has the ability to affect good and gain time and things of that nature. And good and gain time is an administrative action as well. So, does the state have anything to add? And before I do that, the defense and the state, just to make sure everyone is clear, when the court indicated about the options under 3.170G, the court in no way would be doing that on its own motion. That would only have to be the motion by the state of Florida, which would believe to be the aggrieved party. Okay? Second thing that we've talked about at the sidebar on the record was the issue of the former testimony. Upon doing some research in my chambers area, I believe if you closely read Earhart again, that former testimony would make it admissible in civil proceedings under civil procedure rules. But if you read clearly into Earhart, it talks that depositions cannot be used in criminal procedure unless the rules of criminal procedure authorize it, and that's going to be a lengthy issue. So, Mr. Lewis, anything we want Mr. Hooper to convey to Mr. Davis?
No, Judge.
Mr. Bankowitz, anything on behalf of Mr. Rodriguez from Mr. Hooper to convey to Mr. Davis? Okay. Mr. Hooper, thank you for coming down here. Will you be so kind to join your client in the holding cell and communicate with him, and I'm going to have the lawyers at sidebar again, okay?
Okay.
Thank you. Ms. Forrester, will you join us at sidebar too, please? Thank you. Okay, we're back on the record. State of Florida is present. Defense is present. Mr. Rodriguez is present with the interpreters. Let's bring Mr. Davis back in, please. Mr. Hooper, are we ready?
Yes, Your Honor.
Are you Jesse Davis?
Yeah.
I can't hear you, sir.
Yes.
Okay, Mr. Davis, is the gentleman standing to your right, Mr. Jerry Hooper, your attorney? You have to answer out loud, please, sir.
Yes.
Okay. Have you had a conversation with him about your testifying in court today in the holding cell?
Yes.
Okay. Raise your right hand, Madam Clerk. Yes, it is.
You solemnly swear the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay. Ready to bring the jury in, state?
Judge, I think we should offer a Q&A before we do that.
From the court?
Yes.
Okay.
Right to cross-examine and did cross-examine him. So my proposition is that if he is unavailable for either mental reasons or his own reasons that he will not testify, and it's not because he can be held in contempt, and it's not because he has a Fifth Amendment privilege. The issue here is he is not available for us to call as a witness if he refuses to testify, and I submit to you under the rule, even though the court indicated that this is in civil depositions, there are parts of Earhart which specifically discuss civil and criminal as long as the other side has an opportunity to cross-examine him, and they did.
What the court's procedure is going to be this afternoon is this. He is under oath. The jury is not in the courtroom. It's Mr. Lewis's objection that you cannot call a witness for the pure purpose of impeaching. So, at this point, he is here with his lawyer. He's under oath. Let's do the inquiry outside the presence of the jury. If he answers the questions, we go from there. If he doesn't, we go from there as well. So, Mr. Bankowitz, your witness, and when we're done with this, we'll go from there if we're bringing the jury back in or not. Okay?
Yes, sir.
Go ahead.
Mr. Davis, do you know Hector Rodriguez? Isn't it true, Mr. Davis, that you previously advised me that you know Hector Rodriguez? Are you going to answer my question, Mr. Davis? Isn't it true, sir, that you told me that you knew Mr. Rodriguez for a couple of years? And that you knew him from on the street? Are you going to answer my question, sir? Sir, you've received 2 consecutive life sentences in this case. Is that correct? Isn't it true, sir, that you have received 2 consecutive life sentences?
Mr. Davis, the court is ordering you to answer Mr. Bankowitz's questions. Mr. Bankowitz, next question.
You testify.
Next question, Mr. Bankowitz.
Mr. Davis, in accordance with your plea agreement, did you agree with the state of Florida to cooperate in this case? You remember your answer, sir? You answered me yes.
Mr. Davis, I'm ordering you to answer those questions. Mr. Davis, is there any legal reason why I should not hold you in direct criminal contempt for failing to answer Mr. Frank Bankowitz's questions?
I hear voices. I hear voices.
Any legal reason not to hold you in direct criminal contempt, sir, for failing to answer Mr. Bankowitz's questions?
Because I hear voices.
Hearing no legal reason, I hold you in direct criminal contempt. Anything in mitigation you want to say before I impose sentence, sir? Hearing no response, you are adjudicating direct criminal contempt. You are sentenced to 179 days in the Orange County Jail consecutive to any other previously imposed sentence, the court also directs the Department of Corrections to forfeit any good or gain time or any privilege or right or expectation beyond your sentence. You'll be fingerprinted. You have 30 days in writing to appeal the judgment sentence court in writing. If you cannot afford an attorney, one will be appointed to represent you. Do you understand, Mr. Davis? I see your head moving up and down. Verbal response, please, sir.
Yes.
Holding self for him, please, after he's fingerprinted in my presence. While he's being fingerprinted in my presence, the court, through Madam Clerk, administered the oath pursuant to 90.605, subsection 1. Next statute that's involved is 90.603, disqualification of witnesses. There's two subsections. A person is disqualified to testify as a witness when the court determines that the person is, number one, incapable of expressing himself or herself concerning the matter in such a manner as to be understood, either directly or through interpretation by one who can understand him or her. 2, incapable of understanding the duty of a witness to tell the truth. The defendant took the oath under 90.605, so subsection 2 does not apply of 90.603. 90.603, subsection 1. The last part of it deals about interpretation. This is not an issue of the need for a language or sign interpreter. The question for the parties now is, based upon Mr. Davis's conduct on the witness stand, is he incapable of expressing himself concerning the matter in such a manner as to be understood? Mr. Bankowitz, your witness first.
Judge, unfortunately, I can't see into his mind, so I don't know what he understands or doesn't understand. The court's been advised that he's indicated he's hearing voices, and those voices tell him not to testify or not to answer questions. I would submit to the court that mentally he is not competent, but I'm not the person who's objecting to this. It's a state, and under the rule that you cited, they've got to establish the capacity or the mental lack of capacity is the way I read the rule. And again, I've got to go back to 980322, former testimony. I believe we should be able to use the deposition. If we can't use the deposition, my client's constitutional rights are being substantially violated in that he has a right to present a defense without his own testimony, and he's being prevented from doing that.
State your response to the court's inquiry question and also to Mr. Bankowitz's response.
Judge, first we'll take the repeated requests to use the prior discovery deposition as evidence in the criminal case. I'm reading from the 2012 edition of Professor Earhart's evidence book for Florida, quoting, however,
What section and page, please?
I just said 1038 in the 2012 edition. However, the Florida courts have refused to apply a similar rationale in criminal cases and have held that in criminal prosecutions, a discovery deposition is inadmissible under Section 9804, paren 2, paren A, as substantive evidence because the Florida rules of criminal procedure are controlling, and they do specifically provide for such admission, citing to footnote 16, which reads on page 1038 into 1039, Rodriguez versus State, 609, Southern 2nd, 493, Florida Supreme Court, 1992. When defendant offers a discovery deposition of unavailable witness under Section 9804, paren 2, paren A, the deposition is inadmissible as substantive evidence unless opposing counsel is alerted by compliance with Rule of Criminal Procedure 3.190, paren J, that the deposition may be used at trial. That is the motion to perpetuate deposition, which was not done in this case, citing to Hernandez versus State, 608 Southern 2nd, 916, Florida 3rd DCA, 1992. When defendant offered a discovery deposition as substantive evidence, the trial court did not err in excluding the evidence. A discovery deposition, however, is not admissible as substantive evidence if it fails to comply with Florida Rule of Criminal Procedure 3190, paren J, which establishes the requirements for perpetuating testimony. See State versus Clark, 614, Southern 2nd, 453, Florida Supreme Court, 1992. Admission of discovery deposition under Section 9804 as substantive evidence violated defendant's confrontation rights under the U.S. and Florida constitutions. The erroneous admission of the deposition is subject to a harmless error analysis, citing Leihty, Leighty versus State, 981 Southern 2nd, 484, Florida 4th DCA, 2008. Exculpatory discovery depositions was inadmissible under Section 9804, paren 2, paren C. And it goes on basically to say that nobody, the state nor the defendant, can use a discovery deposition in a criminal case unless it was done as a motion to perpetuate testimony, which alerts the opponent that this is going to be in lieu of trial, and you need to cross-examine as if it were in trial and not sit idly by as if it's a discovery deposition.
Judge, I also want to bring the court's attention, if I may, to authority supporting my previous argument about calling Mr. Davis for the sole purpose of impeaching him. I want to direct the court's attention to Apfel versus State, APFEL versus State. It's a 5th District Court of Appeal case, 429 Southern 2nd, 85. Florida courts have recognized that where the state, knowing that a witness will assert his right against self-incrimination, nevertheless calls that witness who is closely identified with the defendant or similarly implicated, and the witness does in fact claim the privilege, the defendant is thereby prejudiced. Where the court and the prosecution are aware that the witness will invoke the privilege, it is improper for the court to permit the jury to hear the witness invoke the privilege. The rule applies to preclude the defense from calling a witness to the stand for the purpose of invoking the privilege in front of the jury. The site is Favor versus State, 393 Southern 2nd, 49 from the 4th. If it appears that a witness intends to claim the privilege as to essentially all questions, the court may in its discretion refuse to allow him to take the stand. Neither side has the right to benefit from any inferences the jury may draw simply from the witness's assertion of the privilege.
Spankowitz?
Judge, first of all, I had no intention on calling him so he could assert the Fifth Amendment privilege. That would be absurd, and I think a violation of professional rules of conduct. But, Jesse Davis, talked to him this afternoon. That's when I found out he was not going to testify. And so, to perpetuate his testimony, we couldn't perpetuate his testimony. We had his testimony. The state spent a number of pages during that deposition cross-examining him. Both counsel cross-examined him. I believe they had an ample opportunity.
The rules are the rules, and 3.190J is one of the rules in regard to criminal procedure. For Mr. Bankowitz, you would have no way of knowing that this action would have occurred today, because you took his deposition, and at no time during that deposition, based on your representation at the sidebar, that you had any idea that he would not be testifying in conformity to what he said at his deposition, correct?
Especially not that he would refuse to take the oath or he would claim the Fifth Amendment privilege.
But the lawyer's questions, if he were on the witness stand and he just sits there and does not respond in a verbal or physical manner, any question you ask is not substantive evidence. So if he just sat there with Mr. Hooper standing next to him, would not be evidence. And I specifically instruct the juries on that. What the lawyers say is not evidence, and that's one of our standard jury instructions. I agree with you that this is not exercising someone's Fifth Amendment right to remain silent, calling a witness situation. The question the court is resolving now is if he is disqualified as being a witness. If he's disqualified as a witness, he is disqualified, and the next thing I do is ask you to call your next witness.
Judge, if in the event the court disqualifies him as a witness, I think the jury needs to be instructed that the court has legally established a basis to disqualify him as a witness, and that it had no bearing on the state or the defense at this point in time.
Mr. Bankwitz, you know that I will take responsibility for things so that it does not affect either party. Is that acceptable to the state if I disqualify the witness? Mr. Lewis.
You asked if there's anything additional?
Oh, anything additional?
No, I don't have anything additional.
Okay. Mr. Bankwitz has requested that if I do disqualify him, I inform the jury that he has been disqualified as a witness, and my curative instruction is that they were to make no inference on the fact that he entered the courtroom. Is that acceptable to the
jury observe of him so far?
He's in a blue corrections outfit. He has belly chains and handcuffs in the front, leg irons on. I think he had slides on. Came up in front of the jury box, raised his right hand as best as possible. When Madam Clerk administered the oath, his response was, "I'm not testifying," or "I don't want to testify." I mean, Madam Court reporter has it exactly, but I had him sit down and excuse the jury. That was it.
That's fine, Judge Ben. Based on the fact that that did occur, I don't have any objection to that instruction, that statement by the court.
Mr. Bankowitz, your objection on this issue is perfected for purposes of appeal.
Thank you, Judge.
Okay. Now, before we bring in the jury, who is your next witness?
Well, if he elects to testify, it would be my client, Your Honor, but I would ask the court to inquire of him as to his right to testify and whether he intends to or not.
Yes, sir. Are you Hector M. Rodriguez?
Yes.
State of Florida, if Mr. Rodriguez takes a witness stand, do you have a good faith basis to ask him whether or not he has been convicted of a felony?
Yes, we do, Judge. As we indicated on the record before, we have, based on our records, 2 felony
And you have a good faith basis to ask him if he's been convicted of a crime of dishonesty or false statement?
Correct.
Mr. Rodriguez, do you understand that if you take the witness stand, your attorney or the state of Florida can ask you whether or not you have been convicted of a felony? Do you understand?
Yes.
If your answer is yes to that question, you must answer the next question. How many times? Do you understand? How many times you have been convicted of a felony? Do you understand? You have to answer that question. Do you understand that you have to testify truthfully to that question?
Yes.
Do you also understand the state of Florida or your attorney can ask you how many times you've been convicted of a crime involving dishonesty or a false statement?
Yes.
If you answer yes, you have to testify to how many times. Do you understand that as well?
Yes.
Do you understand that you have the constitutional right to testify and you have the constitutional right not to testify? If you exercise your right to testify, I will specifically instruct the jury as follows. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. Do you understand that instruction?
Yes.
If you exercise your right not to testify, I will instruct the jury as follows. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove a defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you understand that instruction as well?
Yes.
If you do testify and you do answer the questions that you've been convicted of a felony or a crime of dishonesty or false statement, I will add to the jury instructions under weighing the evidence that the jurors can weigh your credibility because you have been convicted of a crime constituting a felony or dishonesty or false statement. Do you understand that as well?
Yes.
You've got 2 felony convictions, 1 possession of cocaine, 1 delivery of cocaine, and you've got 2 petty thefts, which are dishonesty. That's a crime of dishonesty is stealing. So total you've got 4, 2 felonies, 2 dishonesty. Okay, you understand that? So if they ask you if you've ever been convicted of a felony, you can say yes 2 times. Dishonesty, yes 2 times. That's what the judge is asking you. Okay.
At the end of the day, this is completely your decision if you want to testify after consulting with your attorneys. If Mr. and Mr. Bankowitz both beg you to take the witness stand, you do not have to. Do you understand?
Yes.
And the opposite as well. If they beg you to take the witness stand, you don't have to. If they beg you not to take the witness stand, you can take the witness stand. Do you understand that?
Yes.
Have you had a meaningful opportunity to discuss with them whether or not you want to testify?
Nosotros hablamos, pero me gustaría hablar algo con ellos antes de decidir si voy a testificar o no.
We talked about this, but I would like to have the opportunity to talk about this with them, about whether or not I should testify.
Okay, you may do so at council table, and we will turn off the record so you can do that in private. And then when you are done, I will ask you what your decision is. Do you understand? Okay? We'll be at ease for a few moments.